Welcome to PM Express. Finally, the James Gyakye Quayson verdict is out. That full judgment of the Supreme Court is out. I remember that the minority in Parliament had actually threatened that they were going to object the approval of the new Chief Justice if they didn't get a certified true copy of the judgment by the reopening, the resumption of Parliament. Well, that document is out now, and today, as we now know, they have read it and they've taken a decision that they will now give their backing to Justice Tokonu, who we are expecting that the Parliament will be considering pretty soon, and there will be an approval because there's now some consensus. But that is to say that the NDC indeed supports the nomination of the new Chief Justice. Doesn't mean that they are okay with the text and the reasoning in the judgment. And that's why we're asking the question, having now read it, why is the NDC still aggrieved? And today there was a press conference where they laid out their issues when it comes to this particular judgment. And so let's try and interrogate that a bit more here on PM Express. A few things that we know as far as this judgment is concerned is the Supreme Court's own focus on what this constitutional provision means, this Article 94(2)(a), which really was at the heart of the controversy in the Supreme Court, which emphasizes the allegiance and what will disqualify you. Cannot be a member of Parliament. A person shall not be qualified to be a member of Parliament if he owes allegiance to a country other than Ghana. So in this case, Chief Gyakye Quayson, the Supreme Court held in this matter that he owed allegiance to Canada, right? And so instantly, the Supreme Court says, once that determination is done, you cannot run as a member of Parliament. You cannot run in the parliamentary elections, which really was the basis of the verdict that they have now published for all of us to see. We'll come to some of the specifics pretty shortly, but this is a fundamental issue of contest in the courts. Now, according to the Supreme Court, a few things, and this is just to draw the timelines for you. For many of you, of course, have not followed this from the beginning. Started all the way back on the 1st of January when the plaintiff statement of case was laid before the courts, and then you have the Gyakye Quayson himself as defendant also put in one, and then a first defendant files also. So this has traveled all the way filled with controversy. But for me, this is one of the key elements in this judgment that was key. Also, if you read it, it comes down to what the Supreme Court and the first defendant himself had put forward, that James Gyakye Quayson commenced the renunciation process, and the timelines are important. Renunciation process of his Canadian citizenship in 2019. Although he secured his renunciation, this is very important, the timelines. He secured a certificate in November 2020 after he had filed the nomination forms. And the Supreme Court in this judgment is very clear that this disqualification is at the time.
Wendy's is open till midnight or later, so you can give in to the craving and go night mode. Now all of your favorite menu items just got their bedtime extended. You can get what you want even later, like the Baconator with 6 strips of bacon, or the perfect fries and Frosty Duo. If you're up later, then so are we. So go ahead and pull through the drive-thru. When the craving hits, go night mode at Wendy's. Open till midnight or later. All right, see ya later.
At participating U.S. Wendy's, hours may vary.
The time that you were filing. So the time that you were filing, you should have had evidence to prove that you owe allegiance to Ghana and no other country. In this case, they found that he owed allegiance to Canada as well after the time that he was filing. The NDC had argued that the time issue kicks in, the time that you get disqualified kicks in at the time of voting. And they've quoted the PNDC law to back this, but the Supreme Court rejected that proposition, indeed. And so this really was the timelines. At the time of filing, you should be in possession of your renunciation certificate. And he wasn't in possession of that, which indeed then became a subject of controversy and a subject that the Supreme Court analyzed and came to that conclusion, as you've seen. A few of the key issues that the Supreme Court also had to determine on the qualification issue. Gyakye Quayson was not qualified at the time of filing, which is the point that I'm making. And this is trying to break it down for you, the key elements that the Supreme Court had considered. this issue of qualification and the time is so important. I'm sure when we sit down for a conversation, it will come up again. Gyakye Quayson was not qualified at the time of filing his nomination forms. The NDC disagrees with this. Is one of their key issues of disagreement, and their grievance now, even having read it, revolves a bit around this as well, because their time for qualification, disqualification kicks in according to the NDC at the time of voting, which is what they call the PNDC law. And then also the subject of the permission to contest the 2020 elections, the EC decision, as far as the EC looked at the Gyakye Quayson's documents, and then they felt that because he's begun the process and had renounced it then, although he didn't have the certificate, he could contest. The Supreme Court disagrees with that. And that definitely, going into the 2020 elections, raises another issue of reform. The EC, the Electoral Commission now, it will be mandated, I believe, on the back of this judgment, to not only take the word of the Member of Parliament for it, but see, in cases where it's evident that the individual who is seeking to be a Member of Parliament may owe allegiance to other country, see that renunciation certificate before you clear him to go and run in elections. And that, I guess, is one of the fundamental implications of this as well. And then if you look at the Assin 2020 parliamentary elections, the election of Gyakye Quayson was unconstitutional, therefore his name was completely expunged. That we know already, we covered that extensively. And the directive was to Parliament to expunge his name from the list as a result of this. Now, according to the Supreme Court, and this is another key thing about the renunciation, okay, the qualification of the holding only Ghanaian citizenship must be present at the time of nomination. We talked about that. Then the allegiance question. Allegiance question. What does it mean? The Supreme Court says the two, citizenship and allegiance, they are intertwined. Allegiance means citizenship, and citizenship is a matter of law. And I find this really fascinating because it really clears all doubt. Because, and as the plaintiffs in the matter had said, you cannot intrude into a person's mind to sort of figure out his allegiance. There must be an objective way of assessing that. And that objective way, they argued, has to be citizenship. Okay? And it's very objective. I am a citizen of Ghana. My documents back that. If that is the case, then I owe allegiance to Ghana. If you're a citizen of Canada, then it's an objective way of assessing where your allegiance lay. And that is exactly what the Supreme Court was dealing with here, and clears all doubt when it comes to allegiance. So citizenship is the way to determine a person's allegiance, and that is fascinating indeed. We'll get to hear the lawyer's view on that as well. Now, this has triggered significant ramifications, right? The obvious one is what we're now witnessing, the fight in Parliament, right? The minority, we know, they suspended its consensus approval of the Chief Justice nominee, pending the full judgment. That is now out. And as we know today, they've come full circle to say, well, we've seen it now, we'll let him go, we'll let her go. And it hasn't been approved, but we anticipate that Justice Tokonu's nomination will be approved by consensus in Parliament. Why? Because the judgment is out and the MPs have read it, and that was a condition. Now they've seen it, they disagree with it, but because that was a condition, they will allow it to go. So this, we believe, will be settled. And also we know now that there's a by-election as a result of the Supreme Court judgment. That by-election is pretty interesting, and there's a lot more going on there. We'll show you what has been happening in Assin North. As we see, the minority caucus, they have their own reactions to this. They disagree with the ruling of the Apex Court. They back the approval of the nominee now after seeing the document. And as we know, they are bringing back James Gyakye Quayson to contest in elections. Both the NPP and NDC have pitched camps in Assin North right now. And this is a judgment that made that by-election possible, right? And so they are going head to head. It is a brutal context of the survival of the fittest. Whoever can convince the people in Assin North that they are, of course, they hold the promise of turning around the constituency in this fortune system, may win this also. And as we've seen, the MPP is expected to conduct its primaries to elect a candidate in Assin North tomorrow, one person will emerge in that, and then they will have a candidate, because the NDC, they already have their candidate, James Gyakye Quayson. And by the way, James Gyakye Quayson, we understand, is also launching his campaign in the constituency tomorrow. So tomorrow is going to be a big day in Assin North indeed. But ahead of that, there is a flurry of state developmental projects underway in Assin North. Roads are being constructed, as you see there. Roads, the culverts, the gutters, the drains, they're all being done. This is the transport minister who is himself on the ground overseeing these roads that have been done, and he's been touring the place and seeing it for himself. And you see him there with his team inspecting. And yesterday we got a bit more detail on this. The national organizer of the MPP had told us that Henry Nanabuache here on PM Express that they have more than 100 projects there. All of them will be commissioned. The president is starting with the commissioning spree next week, commissioning a 32-kilometer road that had been constructed through that particular part of the Ashanti region. So there's going to be a flurry of activity there, and we're going to be pitching camp there. So we'll bring you everything else. This is one of the implications of the judgment. And we'll sit down and have a conversation and try and, now that we've seen the judgment, we need to ask the question, why is the NDC still aggrieved? We'll get into the aggrievance still and help you appreciate the implications of this going forward. Stay with me here on PM Express. After that, my guests will be seated.
Crazy pa. No, somebody know me.
Whiskey.
Wash. All of a sudden, my voice I hear different. And when you saw a call, barman, bring me the honey whiskey. You know the one, Black Rock whiskey.
Honey whiskey.
Chalet, honey near their frau. Black Rock whiskey is strong. Now so taste me is smooth and it goes down easy. Excuse me. Barman, bring my friend one Black Rock whiskey.
Black Rock whiskey, blended with natural honey flavor.
Hey, what's up?
Barman.
Hey, what the hell for Sikanton Sata? You've been to a man, no?
Black Rock whiskey can be a feeling smoothness, no?
Drink responsibly. Not for sale to persons under 18 years of age and not recommended for pregnant women. This advertisement has been vetted and approved by the FDA.
My name is Tina. I am a person living with HIV. I got to know my HIV status after I gave birth and lost the child because of HIV. In those days, prevention of mother-to-child transmission services had low patronage due to fear and stigmatization. Today, many HIV-positive women have delivered negative children. I follow the guidelines and take my HIV medicine called ARVs every day, as prescribed by my doctor. This makes me strong and healthy, and also prevent me from passing HIV onto any future child. Please, avail yourself for PMTCT services when pregnant. It is the only way to ensure you do not pass the HIV onto your baby during birth or pregnancy. If you have tested for HIV recently and it was negative, test again when pregnant. If you have tested positive, go to the hospital after birth as directed by your healthcare provider. Your baby will be given medicine immediately and tested to ensure baby and mother are well. Let us work together to have an HIV-free generation.
Our children must be free to shine.
crystal clear and thrilling podcasts and live shows, download and listen to us on Apple, Spotify, TuneIn, Google Podcasts, MyJoy Online, Amazon services like Echo, Amazon Music, and Audible, Stitcher, Adom Online, Overcast, and Pandora. Take note of everything. Sign up for the multimedia digital platforms now to stay updated.
We've had news file over the weekend, and an interesting part of the conversation focused.
Oh no, we are out of range.
Oh, don't worry, Daddy. I have Alexa in my bag.
Alex, what?
Alexa, open Multimedia Ghana and play Joy FM.
Super Hits Radio, Joy 99.7.
Listen to Joy FM, Hits FM, Love FM, live on your Amazon Echo. Listen to your favorite multimedia radio stations live on your Amazon Echo device by saying, Alexa, open Multimedia Ghana, play Joy FM or Hits FM or Love FM. Or catch up on your favorite podcast by saying, Alexa, play, and then the name of your favorite podcast from Multimedia Ghana. For a list of all podcasts available, say Alexa. Ask Multimedia Ghana to browse programs.
On air. And we are back like we never lost signal.
Alexa, welcome to Multimedia.
Can he tee up someone in red? And it goes to one!
Do not say! I got 5 champions league. You want to know? I be the real goat. Chairman. I be the real goat. You left magician. You left magician.
Who is the goat? Ghana Jollof or Nigerian Jollof?
Ghana Jollof has no co-equal. The smell alone. Oh my God.
No, that shit. You two they lie. Eh? Now the same stew when they use cook the rice and then they go put them for top.
Hey! You are lying. Ghana Jollof.
Are you here? Forget everybody. Yeah. My guy. Put some respect on the goat.
On the goat. The only goat I know lives in Tama.
Every year we they give to you back.
We are talking about BET. I want some Yaji face.
Except be the goat, huh?
My guy, him be the goat.
Though our choice of goats may differ in football, music, and jollof, Alomo Bitters always brings us together. Alomo, experience greatness in every moment.
Drink responsibly. Not for sale to persons under 18, nor recommended to pregnant women. This advert is FDA approved.
EcoBank salary account, bro. With the EcoBank salary account, you will enjoy free life insurance, free debit card, save while you spend, and an amazing chance to double your salary. And even more consolation rewards in the EcoBank double salary promo reloaded.
Guy, this EcoBank salary account sounds interesting. What do you think?
Yeah. But maybe next time, Charlie, you know what? I'd go shine my shoe.
Hey! Yo, myself, I'd go check my BP.
We going up, never go down, and we stay fly.
Chairman, you see the white sign it here.
Open an EcoBank salary account today for a lifetime of benefits. You also stand a chance to win more than double your salary in the EcoBank Double Salary Promo Reloaded from now till July 31st. Terms and conditions apply.
Progressive presents an ad from Mom.
When you bundle your home and auto insurance with Progressive, bundle, that's a cute word. What? Read it again? Okay. When you bundle your home and auto insurance with Progressive, you get round-the-clock protection. Oh, that's darn good. Because once my older sister Dottie, her basement flooded.
Get round-the-clock protection when you bundle and save with Progressive. It's easier than getting your mom to make this radio ad. Progressive Casualty Insurance Company, affiliates, and other insurers. Discount not available in all states or situations.
Wendy's Strawberry Frosty is back for the summer. Because if it's summertime, it's Frosty time. Beach time, Frosty time. Tea time, Frosty time. Me time, Frosty time. Treat yourself to Wendy's Strawberry Frosty this summer and make time for Frosty time. Choose wisely. Choose Wendy's. Now open till midnight or later. Limited
limited time only. Participating U.S. Wendy's. Hours may vary.
This program is under the supervision of the National Lotteries Authority under the Caritas Lottery Platform.
Simba Foundation of 15! Hooray! Thanks be to God. Mama Zimbi Foundation, empowering widows for economic independence. On the 10th of June, a crowdfunding Yeshia and will Breaking New York Ministry International, Klagon, from 8 a.m. to 4 p.m. Sadano, New Christian Hospital, Ebema Ekrafono, free screening and health talk. Mama Zimbi Foundation, 15 years anniversary year, empowerment. Any energy and kwa, we are Kweni Ba, Menu Fimo, if we say, Ekraya Wohoi, and Yebia Bo, Ekrayo, Nyame, and Washishe. Yen supporters near Daniel Milk, Minata and Daughters Porridge Serving, Bell Aqua, Frightor, Fortune Rice, Hunger, Last Hour Catering Services, Top Choco, Blue Skies, Flower Tissues, EJ Enterprise, Indomie, Awake Purify Water, Taste It Home, Media Partners, Adum FM, Asempa FM, Inshira FM, Adum TV, and Apega TV.
And thanks for staying with us. In the studio with me is Mahama Ayariga, is MP for Boku Central, and he addressed the press today on behalf of the minority on the back of the written judgment that they now have a copy of. And thank you very much for joining us here on PM Express. Also joining me right now via Zoom is Kweku Pencil. He is a managing partner at Pencil & Pencil & Co. Hello, Mr. Pencil. Thanks for your time here on PM Express.
Thank you. Good evening.
Great to have you join us. Mr. Ayariga, so you have now seen the full judgment. What's your initial assessment of it?
Well, I mean, thank you very much for the opportunity. The minority members of the Appointments Committee wanted to further assess the depth of the jurisprudence of her leadership, the Chief Justice nominee, Justice Gertrude Araba. Really, for me, the reasoning in that judgment is very disappointing. Very disappointing in the sense that when you read the judgment, you find out that the court veered off from the real issue before them and focused on another issue that, strictly speaking, is not the province of the Supreme Court.
What do you consider to be the real issue before them?
The real issue before them is whether or not at the time of becoming a member of parliament, that is when your allegiance to the country needs to be established.
Right, for that time of becoming a member of parliament, is it at the time of swearing in, at the time of the elections, at the time of filing? So there are three key processes leading to that. Which one are you referring to?
Good. Today, the MP for Assin, Kumewu, was introduced to Parliament as the person who was elected to represent Kumewu. The first thing that took place was for him to take the official oath and then to take the oath of allegiance. Oath of allegiance. So it is today that he swore an oath to us to assure us that he owes allegiance to the Republic of Ghana, and implicitly that he does not owe allegiance to any other country. the significance of that event is that it is at the point that you are taking your seat that the question of your allegiance becomes critical. The issue of when you pick nomination forms to when the election is conducted are matters within the province of the Electoral Commission. And if you go to Article 51 of the Constitution, it states clearly, and you can go to Article 51, it states clearly that the Electoral Commission shall, by a constitutional instrument, make regulations to govern the conduct of elections. And if you go to the Representation of the People's Law, PN's Law 286, that also governs the regulation of the conduct of elections, dealing with filing of nominations and etc. And then the various CIs. Those are the CIs that always come, and then we are fighting over whether you should use Ghana card or not use Ghana card, and whether you should use your birth certificate or not use your birth certificate. Those are matters that govern the processes leading to your filing of nominations, your registration as a voter, and then the conduct of the elections, how the results are collated, how it is declared. All those are housekeeping administrative matters before you get elected.
But you've introduced another element, which Gyakye Quayson and his team didn't argue before the court.
Yeah.
Their argument was that your disqualification would be triggered at the time of election, not at the time of swearing in. So they disagree with you in what you're saying right now.
Indeed, there are two developments that, in my opinion, that mislead or have misled the court. The first development was the case of Zaneto.
Yeah.
In that case, the issue was whether or not Zaneto, who had beaten Niama Ashite in the NDC parliamentary primaries, but who Niashite claimed was not a registered voter in that constituency, whether or not by virtue of that development she wasn't qualified to contest as a parliamentary candidate in Osuklote constituency. And in that case, it was actually NDC, as an interested party, that argued that the point for determining eligibility to contest elections is at the point of filing nominations with the Electoral Commission. The Supreme Court bought into that argument.
And referenced it here in making the argument.
Okay, they bought into that argument. And then they established a principle that the point for determination of eligibility to contest elections is at the filing of nominations. Now, in the Quayson case, as you also rightly pointed out, they tried to push it to the actual elections, hoping that the Supreme Court will buy into that argument. But the court rejected that argument and then took a position of an earlier timeline, which is the point of filing of nominations. My contention is that both timelines are wrong.
So your timeline should be at the point of swearing in?
Indeed, because the Supreme Court itself really has no mandate when it comes to questions of filing of nominations and etc. Because if you read the language of Article 94, Article 94 doesn't talk about eligibility to contest elections. Article 94 talks about qualification
of a member of parliament
to become a member of parliament. Qualification to become a member of parliament. At what point do you become a member of parliament?
But Mr. Yaga,
that is a critical
question. Throws up a possibility of some absurdity here. Let's follow me here.
Yes,
so, if you say that the disqualification can be triggered at the point of swearing in, remember that the sanctity of the vote, when the people have already queued, voted for the individual, only to now, at the point of swearing in, now make that determination. Aren't you now entering into a territory now of discounting that, that all-important element of our democracy, of people's exercising their right to vote and choose an individual. And they're entitled to know if the person that they are voting for, before they vote for the person, is indeed qualified in the Constitution to even earn their vote. That is an absurdity that your proposition creates.
But that the Constitution has made provision for. And so the Constitution says that the Electoral Commission shall make regulations governing the conduct of elections. That is why the Electoral Commission makes regulations to determine your qualification and how to prove your qualification to even register as a voter. The Electoral Commission then, prescribes what forms you should fill to contest elections, what they want to see, what information they want to gather in that form.
This is part of the pre-qualifying conditions, even for the Electoral Commission.
Exactly. But that is the province of the Electoral Commission. That is why we say that the Supreme Court had no business in this matter.
No, but so if the Electoral Commission is acting against the Constitution, the Supreme Court can't step in.
But the Electoral Commission was not acting against the Constitution.
But the Supreme Court actually determined here that it did. That it was.
And we are saying that the Supreme Court is wrong because the Supreme Court's province or mandate was under Article 94 2A to determine whether at the point when Quayson became a member of Parliament, whether he was qualified to be a member of Parliament, whether at that point he owed allegiance to another country other than Ghana. That was the province of the Supreme Court. Every other thing is the responsibility of the High Court and administratively the Electoral Commission. And the Electoral Commission clearly thought that Quayson was qualified to file his nominations. On the date of election, Quayson had already renounced his citizenship of Canada.
He had not renounced.
On the day of election?
Yes. On the day of elections, yes.
Yes, on the day of election, he had renounced.
By the time of filing, he didn't.
Yes, but the same Electoral Commission looked at the documents and then agreed that he should file. Because, like I said, you see, there are no specific legislative provisions on qualification in the Representation of the People's Act. So, if anything at all, there is some vacuum in terms of what the regulations should spell out. But it is the responsibility of the Supreme Court to simply say, look, if you are concerned about eligibility to file nominations, that's a matter that Parliament can provide for in the Representation of the People's Law. They haven't made express provision for that. But as a Supreme Court, ours is to interpret the text of the Constitution. And the text of the Constitution in Article 94 2A is simply saying that nobody shall be qualified to be a member of Parliament if that person owes allegiance to another country.
Stay with me. Let me bring in your learned friend, Mr. Pence. Mr. Pence, so do you agree with Mr. Ayariga's view on this part of the judgment?
I fundamentally disagree with my good friend because I don't really agree with him at all, and I will explain why I don't agree with him. But if you permit me, let me preface my real answer with some observation that we all need to appreciate. At least that's the Supreme Court is the final arbiter, not because they are the wisest men in the land, but because litigation must always have an end. And therefore, when the Supreme Court has made a judgment, it is the right of every Ghanaian, anybody, to disagree with them on points of law, on issues of fact, whichever way one thinks of it. So what we are doing is indeed a healthy exercise. And therefore, my learned friend can take his position. But essentially, the real point I want to make is that the position that he has taken is a position that was argued before the Supreme Court, and the same was rejected by the Supreme Court as untenable. And let me make my own observations. You know, we've got all kinds of laws in this country, But ultimately, we have the Constitution. The constitutional provision in Article 94(2)(a), which was the article that the Supreme Court had to interpret, was in the light of all subsidiary laws below the Constitution, including the Representation of People's Act. And it is true that the Representation of People's Act does not make specific provisions like my good friend said. But what the Supreme Court did was what we call an interpretation. An interpretation of all the laws to make sense, in one direction. In other words, Article 94(2)(a) is very specific, that nobody can become a parliamentarian. And of course, I'd like you to appreciate that even though that particular provision deals with parliamentarian, there are other disqualifications that people who owe allegiance to other countries are also subject to. But since we are dealing with the election issue, 94(2)(a) specifically deals with that. And if you take it against the Representative Purpose Law, now let me put it this way, specifically with regard to the Zanito case. The Zanito case was an intra-party and within a party issue that arose because the party itself had held elections to nominate a candidate for contest to go to parliament. And the losing parties had come to court on the basis of the argument that she did not qualify per the party's rules of engagement. But what the matter went to the Supreme Court, when the matter found itself to the Supreme Court, the issue before the Supreme Court was whether within the larger laws of Ghana, not the NDC Constitution, NDC regulations, whatever, who qualifies to become a parliamentarian and at what point in time. And the Supreme Court interpreted the issue at that time to say that vis-a-vis the NDC regulation, vis-a-vis the NDC, whatever they have for conduct their own elections, the proper way that anybody could be said not to be eligible to contest for elections is at the point in time that the Electoral Commission has set the ball for contest for people to go to Parliament. So the interpretation that the Supreme Court derived at that point in time had everything to do with whether the NDC, their regulations or constitution, can override the national constitution in terms of selecting candidates to contest for national elections. And we must draw that distinction very, very clearly. And there can be no doubt whatsoever that was the purpose, that was the intendment, and that was what the Supreme Court was saying at that point in time. In the case of Gyakye Quayson, the issue at stake is not indeed what my learned friend is putting it, which is that at the point of swearing in. The law is that you must not even offer yourself for election at all unless at the point of offering yourself. And please, that is the interpretation the Supreme Court has put on it. You may agree, you may disagree. Unfortunately, we belong to different persuasions. And much as he disagrees, there was a contention that was also placed before the Supreme Court vis-a-vis all the other subsidiary legislations that we have. And the Supreme Court has ruled that upon a reasonable interpretation that ought to be placed on Article 94(2)(a), issues of allegiance arise.
Yeah.
And if at the point that you are picking the forms, and please, when I was talking about the Electoral Commission, please don't forget that the Electoral Commission has got a right to supervise, make rules, but they are under the Supreme Court.
Yeah.
Because even in the Gyakye Quayson case, the position of the Electoral Commission under the evidence or the facts before the court was simply that Gyakye Quayson had made a representation to them which they thought was reasonable. But what the Electoral Commission considers reasonable or acceptable cannot be the law in Ghana as long as the Supreme Court takes the view that it contradicts the clear provision of the law.
And you raise that substantive point about allegiance. And I want to shift the conversation there because we've talked about the times and all. But if you read the judgment, it comes down to that point of allegiance. Mr. Payson, stay with me. Mr. Ayega, it comes down to that point of allegiance. And the Constitution provision is very clear, which is that you cannot hold yourself as a member of Parliament when you have allegiance to another country other than Ghana.
Let me ask you some very simple questions.
And that is triggered from the onset.
Let me ask
when you try to file.
Let me ask you a very simple question, and maybe he will help us answer that question. When you pick nomination forms, how does allegiance come in? When you just pick nomination forms that you want to file for nominations to contest as a candidate.
But that is the first door to entering into the chamber of running for. If you missed, in fact, that's why the Supreme Court assessed that the Electoral Commission should have verified that, and they called them out in this particular judgment. That's so key, isn't it?
The point is, everybody has a specific role in the Constitution. Election petitions are specifically the responsibility of the High Court. Okay? The Supreme Court has a responsibility for interpreting.
But this was not an election petition. In fact, they addressed this extensively.
No, listen. The Supreme Court has a responsibility for interpreting the Constitution. The simple question is, what does Article 94(2)(a) say?
A person shall not be qualified to be a member of Parliament if he owes allegiance to a country other than Ghana.
Good. Qualified to be a member of Parliament. All we are saying is that when you go and pick nomination forms, you are not yet a member of Parliament. When you go to contest the elections, you are not yet a member of Parliament. You become a member of Parliament at the point of being sworn in to be a member of Parliament.
No, but the substantive process that takes you to that point is the elections. In fact, the elections is the most important part of this chain you talked about.
Yes.
But how do you get to the elections? You have to go to the Electoral Commission. And that is the point where the Electoral Supreme Court says you have to make that determination.
And we're saying
you can't disagree with that.
And we're saying that the Constitution says that it is the Electoral Commission that should make regulations governing the whole process.
True.
And we're saying that the Electoral Commission has not made any specific regulation that says that when you come to file the nominations, you must bring me, evidence of your renunciation of citizenship of another country.
That's why the Constitution is supreme then. But the Constitution has set the ball already.
No, the Constitution talks about when you become a member of Parliament.
No, it says you shall not be be qualified to be a member of Parliament.
Yes. It doesn't say you shall not be qualified. You shall not be qualified to contest to become a member of Parliament.
No, but you cannot be a member of Parliament unless you stand and be voted for. I mean, it follows, does it not?
We're talking about constitutional interpretation. We're talking about the role of the Supreme Court. It is the role of the Supreme Court to sit and wait. If the Electoral Commission, at the end of the day, declares somebody as having been elected and presents that person to Parliament, and then it turns out that that person, at the time that he is taking the oath of allegiance in Parliament, owes allegiance to another country other than Ghana, at that point, Article 94(2)(a) is triggered. 94(2)(a) is triggered. You see, what the Supreme Court is doing is to assume that there is some vacuum, and then it is interpreting the Constitution to fill in that vacuum. And we are saying that that's not your job. Your job is to sit and wait. If the processes does not produce a candidate that does not owe allegiance to another country, then your responsibility to disqualify the person.
Member of Parliament,
yes,
who owed allegiance to another country.
No,
but the process
didn't.
Well, that they have
at the point of conducting at the point of the process.
At the point of filing.
Listen, the process
to enter the door.
The process produced an individual who, at the point of filing to contest, owed allegiance to another country. Yeah. But at the point of the contest itself, did not owe allegiance to another country. At the point of becoming a member of Parliament, in the language of Article 94(2)(a), did not owe allegiance to another country. the Supreme Court jumped and went to the point of filing, and we're saying that is not your job.
Okay.
That's the job of the Electoral Commission.
Address for me.
And the Electoral Commission doesn't have an issue with that. It hasn't made a law on that.
No, but I get it. I'll come to it. But quickly, address for me the point I make to you about the sanctity of the vote. So, and the absurdity this creates, right? So if you don't deal with it at the filing, you actually will put up a candidate who will be deceiving the people. And the Constitution makes that the most important factor in this whole thing called democracy.
No, there are. Let me respond to that. Let me respond to that.
Isn't that why?
Let me respond to that. Let me respond to that.
Yeah.
Somebody could actually owe allegiance only to Ghana, contest elections, be voted, be sworn in as a member of parliament. After that, go and assume the citizenship of another country in addition.
But that will be dealt with separately.
No, it will be dealt with. It will be dealt with under Article 94(2)(a), the same clause.
Yeah, to disqualify him.
Exactly.
If you do that.
Exactly. So the issue is not when you file nominations. The issue is when you are a member of parliament and at the same time you owe allegiance to another country. Article 94(2) kicks you out.
Let me quickly ask you on that before I come on allegiance question. Do you agree? I know we've spent a lot of time on this first part, but
no, that's the most important issue.
So but you disagree with the Supreme Court, and Mr. Quayson disagrees with you as well. Mr. Paintsell disagrees with you as well. Let's address the second quick point. Do you agree with them on the interpretation of the allegiance being intertwined with citizenship? You don't disagree with that?
I don't have an issue with that because, that really will be a question of the laws of that country. Because usually, every country that is granting you citizenship will usually require that you also take the oath of allegiance to that country. So often, allegiance is intertwined with citizenship. You assume citizenship, you owe allegiance to the country whose citizenship you assume. So it's not a complicated issue. And Quayson is not saying that he, at the point of becoming a member of parliament.
They argue differently on this subject of allegiance and citizenship.
And that's why it's not every argument they made in the court that I agree with.
Okay.
I'm not just following the NDC blindly. I'm saying that my understanding of the 1992 Constitution is that the Supreme Court is to interpret. And what was it interpreting? It was interpreting 94(2)(a). What did 94(2)(a) say? 94(2)(a) said a person shall not be qualified to be a member of parliament. And I'm saying that in this instance, what I heard the Supreme Court doing or saying is that a person shall not be qualified to file nominations to contest elections if the person owes allegiance. I'm saying that's not what 94(2) is about.
Mr. Ayaga, this is precedent to this, right? And the Supreme Court actually in this judgment referred to the Sumala Bilbil's case.
Yes.
At the Musa Kandi,
yes.
Right? And they said this particular case is on all fours with that particular case. First of all, you agree with that?
No, they don't. They probably don't know the facts. The Sumala Bilbil case was a situation where Adamu Dramani had contested, was sworn in, and then it became evident that even whilst a member of parliament, he was also a citizen of the United Kingdom. He was a citizen of the United Kingdom.
Yeah.
He hadn't renounced his citizenship. He claimed to have renounced his citizenship. But then the Attorney General's office wrote to the British government to find out whether he had actually renounced his citizenship, because he presented a document purporting to be a renunciation certificate. And the British government wrote back to the Attorney General's office and reported that that was a forgery and that it did not emanate from Home Office. So it was a situation where he had forged documents. So the action was not under Article 94. It was a criminal prosecution for forgery and other related offenses. And that was what led to his conviction. So it wasn't an action under Article 94(2).
But if you track back, at the time of filing, he was a citizen of another country who he held dual citizenship.
But that's not the issue in that case.
I get what you're saying. There were other things that are different, makes the case sometimes different from this one.
Yes.
But the similarity to this particular case is that at the time of filing, he was a citizen of another country. At the time of elections, you said the 3 timelines. At the time of filing, he was a citizen of another country. At the time of elections, he was a citizen of another country. At the time of swearing in, he was a citizen of another country.
Exactly.
Post that, he was a citizen of another country.
Exactly.
He would take those timelines, at least.
But he never renounced. He never renounced.
But at least, at the first instance, the first timeline, is on all fours with James Gyakye Quayson.
For me, I think that case was a criminal prosecution. It really wasn't, in my opinion, a matter.
But you know that James Gyakye Quayson there's a criminal case against him.
We haven't dealt with that yet.
True, but I'm just pointing out as a fact.
That's not what I'm dealing with.
Also
today.
On perjury.
That's not what I'm dealing with today. And that's why I said that there are other ways of dealing with such matters. Okay? But the Supreme Court's approach is overshooting their boundaries.
Stay with me. Mr. Pencil, on the subject of allegiance, do you agree with the Supreme Court? Sorry, please unmute for me.
So that's the first time that I've heard anybody of that political persuasion agree with the Supreme Court on the issue of allegiance. Because personally, I was getting a little frightened when people make arguments seeking to distinguish citizenship from allegiance. The argument being that you could divorce yourself from those two things, or state of mind that you could have citizenship of a country without necessarily owing allegiance. And I always pointed out, indeed, on a lawyer's platform last week, I solicited. I could understand a woman who can sleep with 100 men, who is a prostitute, and owes no allegiance to any one of them. But not for my wife. I cannot live with my wife, and my wife tells me, in spite of everything, she doesn't owe allegiance to me. So what we're doing is, if that argument that no longer holds, at least I've got one person who agrees with me, then we have some sanctity, we have some sanity, we have something that's been injected. Because it is very frightening to think that, because I pose the question, that so for instance, the argument that we're making, are we limiting it, for instance, to parliamentarians? Does it mean, for instance, that in a future state in Ghana, we could have a defense minister who says that he doesn't owe allegiance to Ghana, but he owes our citizenship? Could we have a president who says that he doesn't owe allegiance to us, but he has our citizenship? But I'm very, very rested and assured that at least I've got one person who agrees with me that distinction that is being drawn is so artificial that an extension of the logic buried in that argument will lead to absurdity of absurdities. And I'm thankful that at least we're now having some common understanding. It's my personal view, and I've heard that view. This is not a question of interpretation of law or interpretation of anything. I've always heard the view that citizenship goes with allegiance, and therefore, if you are one man with 2 passports, you are double-minded. In other words, you have allegiance to both countries, and such people must be limited to the extent of what kind of positions that they can hold in this country we call Ghana. I don't really know too much about what other citizens in other countries who hold dual citizenship are able to do and unable to do, but this is Ghana, the republic we call Ghana, what we hold dear to ourselves. We are entitled to make laws for ourselves regarding those who can hold certain sensitive positions in this country if they wish to remain citizens of other countries. I've heard arguments about their contribution, the contribution of diaspora. Fair enough. We are thankful to God that they're able to do all those wonderful things. But please, it's a choice. Nobody, imposes a duty or a burden, obligation or whatever on anybody to go and take another country's citizenship. People call it a rule of convenience. So be it. But in everything in this life, there are consequences for every decision. As you make your bed, so shall you lie on it. That's the principle. And therefore, it's my view that even the laws that we have are not restrictive enough. I don't mean to degrade, I don't mean to demean, I don't mean to, cast them down. But please, the choices that they have made, they must stand by those choices and leave us those who decide that if there's trouble, we are bound to stay in this country no matter what. They may not allow us even to cross to Togo, and we will hold. And the next flight that they come, you see the evacuation in Sudan, they come to evacuate their citizens.
Yeah, but at least one good thing from this case is that there's clarity again. This Supreme Court took an opportunity to reaffirm the point about the how intertwined those two concepts are. You can't separate them, and so we have clarity on that. Stay with me, Mr. Ping. So let me ask you that.
Now, let me make one more point.
Yes,
with regard to what my good friend has said earlier on. You know, of everything that the Supreme Court said, I mean, having regard to the kind of doorways that my learned friend is trying to give to the 3 doorways or whatever.
Yeah.
I said for public policy considerations alone, if we hold on to what my learned friend is proposing, let me tell you the preposterousness of that argument. Has anybody sat down to ask himself the cost to Ghana of holding a second election, the millions of cedis or whatever? So why must the Supreme Court sit down? Why must everybody sit down and think that we must go through those points, and at a particular point that we must begin to sit up as a country, and all of a sudden we discover that this person has slipped through the door? So I believe, honestly, that the decision of the Supreme Court, in addition to everything else that they have said, is for public policy considerations, the best thing that we can adopt for ourselves as a country. That will not be too late by the time that we find out. Like what we're doing now. Somebody must be paying for that bill. It's too expensive for us to sit as a country and allow matters to drag to the point where it's beyond recovery. So that's the other reason I have.
Okay. Mr. Edgar, is there a case for a judicial review of this judgment?
You see, his last point betrays everything that has happened.
Okay, what's the point there?
It betrays everything that has happened. That people think that, oh, but yes, there is some gap there. We should have clear regulations that spell out that at the point of filing of nominations, you must prove that you owe no allegiance and that you are a registered voter and that you hail from the place and etc. So that going forward, we don't have a situation where we vote for you and then we find out that you owe allegiance to another country and then we will have to go hold another election again and then it costs the state money. Basically, that is a concern.
So you're saying that should be a consideration for the Supreme Court?
I said that is not the Supreme Court's business.
Okay.
The Supreme Court should tell us that there is a lacuna in the law, but it is the province of Parliament and the Electoral Commission to make regulations under Article 51 to deal with those situations. The job of the Supreme Court under 94(2)(a, and I still maintain, is to be at the door of Parliament, and if you are either being sworn in or you are already sworn in and you are a sitting member of Parliament and it is discovered that you owe allegiance to another country other than Ghana, then you are disqualified. And don't forget that there's a penalty also to that, because if it is established that you owe allegiance and yet you swore an oath of allegiance saying that your allegiance is only to Ghana, that's perjury.
Yeah, of course.
And you can go to jail for it.
We know that.
So it's not as if there is no mechanism for dealing with situations like that to deter people.
Finally, is there a case, I haven't read it now, for a review of this matter?
If you ask me, I think there is a case, but I'm not a party in the litigation. So it is Quayson. Quayson is busy participating in the contest to...
I asked that because the party, the legal team, they've applied for an extension of time while they consider the options whether or not to file for a review.
That's what I'm saying, that if you ask me, given the position that I've taken here, I believe that the Supreme Court wrongly decided the matter. And if a party in the matter wants to go for review, I think that there's a very strong case for doing so. The qualification for review, I think it's also known. The fact that you strongly disagree with the case doesn't necessarily mean that, the court will grant you an application for review. There are clear-cut requirements for the court to grant an application for review. But I think that the case is wrongly decided. I think that if the court in future has an opportunity, they should review this decision. I think that the policy considerations are indeed compelling. Like my colleague has said, it will cost us a lot of money if, we take somebody through an entire electoral process and then swear the person in as a member of parliament only to discover that the person owes allegiance to another country, and then contestants will be taking steps to disqualify that person and call for a by-election.
An obvious consequence.
But that is a matter that the Electoral Commission should learn from and then act pursuant to Article 51 and bring regulations to Parliament, and then we will pass it to govern situations
as I
like
indicated, the NDC, they've applied for an extension of time.
Not the NDC, it's the Quayson.
Well, I mean, I spoke to your Director of Elections said this, so that's NDC's Director of Elections. But thank you very much. I know you'll be heading to Assin North.
Inshallah, okay. We'll all be there.
That's another consequence of this judgment, and we'll see the outcome of that election. Mr. Kwaku Pencil, thank you very much. He's the managing partner at Painting & Co. Mahama Yaga, of course, you know him, Member of Parliament for Bawku Central. Enjoy the rest of the evening.